Sessions of Parliament. Summoning. The President from time to time summons each House of Parliament to meet, but the maximum gap between two sessions of Parliament cannot be more than 6 months. In other words, the Parliament should meet at least twice a year. There are usually 3 sessions in a year, that is, number 1, the budget session, February to May. Number 2, the monsoon session, July to September. Number 3, the winter session, November to December. A session of Parliament is the period spanning between the first sitting of a House and its prorogation or dissolution in the case of the Lok Sabha. During a session, the House meets every day to transact business. The period spanning between the prorogation of a House and its reassembly in a new session is called recess. Adjournment. A session of Parliament consists of many meetings. Each meeting of a day consists of 2 sittings, that is, a morning sitting from 11 am to 1 pm and post-lunch sitting from 2 pm to 6 pm. A sitting of Parliament can be terminated by adjournment or adjournment sine die or prorogation or dissolution in the case of Lok Sabha. An adjournment suspends the work in a sitting for a specified time, which may be hours, days, or weeks. Adjournment sine die. Adjournment sine die means terminating a sitting of Parliament for an indefinite period. In other words, when the House is adjourned without naming a day for reassembly, it is called adjournment sine die. The power of adjournment as well as adjournment sine die lies with the presiding officer of the House. He can also call a sitting of the House before the date or time to which it has been adjourned or at any time after the House has been adjourned sine die. Prorogation. The presiding officer, speaker or chairman declares the House adjourned sine die when the business of a session is completed. Within the next few days, the president issues a notification for prorogation of the session. However, the president can also prorogue the House while in session. Dissolution. Rajya Sabha, being a permanent house, is not subject to dissolution. Only the Lok Sabha is subject to dissolution. Unlike a prorogation, a dissolution ends the very life of the existing house and a new house is constituted after general elections are held. The dissolution of the Lok Sabha may take place in either of 2 ways. Number 1, automatic dissolution, that is, on the expiry of its tenure of 5 years or the terms as extended during a national emergency, or number 2, whenever the president decides to dissolve the House, which he is authorized to do. Once the Lok Sabha is dissolved before the completion of its normal tenure, the dissolution is irrevocable. When the Lok Sabha is dissolved, all business including bills, motions, resolutions, notices, petitions and so on pending before it or its committee lapse. They, to be pursued further, must be reintroduced in the newly constituted Lok Sabha. However, some pending bills and all pending assurances that are to be examined by the Committee on Government Assurances do not lapse on the dissolution of the Lok Sabha. The position with respect to lapsing of bills is as follows. Number 1. A bill pending in the Lok Sabha lapses whether originating in the Lok Sabha or transmitted to it by the Rajya Sabha. Number 2. A bill passed by the Lok Sabha but pending in the Rajya Sabha lapses. Number 3. A bill not passed by the 2 houses due to disagreement and if the President has notified the holding of a joint sitting before the dissolution of Lok Sabha does not lapse. Number 4. A bill pending in the Rajya Sabha but not passed by the Lok Sabha does not lapse. Number 5. A bill passed by both houses but pending assent of the President does not lapse. Number 6. A bill passed by both houses but returned by the President for reconsideration of houses does not lapse. Adjournment versus prorogation. Number 1. Adjournment only terminates a sitting and not a session of the House, while prorogation not only terminates a sitting but also a session of the House. Number 2. Adjournment is done by presiding officer of the House while prorogation is done by the President of India. Number 3. Adjournment does not affect the bills or any other business pending before the House, and the same can be resumed when the House meets again, while prorogation also does not affect the bills or any other business pending before the House. However, all pending notices other than those for introducing bills lapse on prorogation, and fresh notices have to be given for the next session. In Britain, prorogation brings to an end all bills or any other businesses pending before the House. Quorum. Quorum is the minimum number of members required to be present in the House before it can transact any business. It is 1/10 of the total number of members in each House, including the presiding officer. It means that there must be at least 55 members present in the Lok Sabha and 25 members present in the Rajya Sabha if any business is to be conducted. If there is no quorum during a meeting of the House, it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in House. All matters at any sitting of either House or joint sitting of both the Houses are decided by a majority of votes of the members present and voting, excluding the presiding officer. Only a few matters which are specifically mentioned in the Constitution, like impeachment of the President, amendment of the Constitution, removal of the presiding officers of the Parliament, and so on, require a special majority, not ordinary majority. The presiding officer of a House does not vote in the first instance but exercises a casting vote in the case of an equality of votes. The proceedings of a House are to be valid irrespective of any unauthorized voting or participation or any vacancy in its membership. The following points can be noted with respect to the voting procedure in the Lok Sabha. Number 1. On the conclusion of a debate, the Speaker shall put the question and invite those who are in favor of the motion to say aye and those against the motion to say no. Number 2. The Speaker shall then say, I think the ayes or the noes, as the case may be, have it if the opinion of the Speaker as to the decision of a question is not challenged. He shall say twice, the ayes or the noes, as the case may be, have it, and the question before the House shall be determined accordingly. Number 3. If the opinion of the Speaker as to the decision of a question is challenged, he shall order that the lobby be cleared. After the lapse of 3 minutes and 30 seconds, he shall put the question a second time and declare whether, in his opinion, the ayes or the noes have it. If the opinion so declared is again challenged, he shall direct that the votes be recorded either by operating the automatic vote recorder or by using aye and no slips in the House or by the members going into the lobbies. Number 4. If in the opinion of the Speaker the division is unnecessarily claimed, he may ask the members who are for aye and those for no, respectively, to rise in their places and, on account being taken, he may declare the determination of the House. In such a case, the names of the voters shall not be recorded. Language in Parliament. The Constitution has declared Hindi and English to be the language for transacting business in the Parliament. However, the presiding officer can permit a member to address the House in his mother tongue. In both the Houses, arrangements are made for simultaneous translation, though English was to be discontinued as a floor language after the expiration of 15 years from the commencement of the Constitution, that is, in 1965. The Official Languages Act 1963 allowed English to be continued along with Hindi. Rights of Ministers and Attorney General. In addition to the members of a House, every Minister and the Attorney General of India have the right to speak and take part in the proceedings of either House, any joint sitting of both the Houses, and any committee of Parliament of which he is a member, without being entitled to vote. There are two reasons underlying this constitutional provision. Number 1. A minister can participate in the proceedings of a House of which he is not a member. In other words, a minister belonging to the Lok Sabha can participate in the proceedings of the Rajya Sabha and vice versa. Number 2. A minister who is not a member of either house can participate in the proceedings of both the houses. It should be noted here that a person can remain a minister for 6 months without being a member of either house of parliament. Lame duck session. It refers to the last session of the existing Lok Sabha after a new Lok Sabha has been elected. Those members of the existing Lok Sabha who could not get re-elected to the new Lok Sabha are called lame ducks. Devices of parliamentary proceedings. Question hour. The first hour of every parliamentary sitting is slotted for this. During this time, the members ask questions and the ministers usually give answers. The questions are of three kinds, namely start, unstart, and short notice. A start question, distinguished by an asterisk, requires an oral answer and hence supplementary question can follow. An unstart question, on the other hand, requires a written answer and hence supplementary questions cannot follow. A short notice question is one that is asked by giving a notice of less than 10 days. It is answered orally. In addition to the ministers, the questions can also be asked to the private members. Thus, a question may be addressed to a private member if the subject matter of the question relates to some bill, resolution, or other matter connected with the business of the House for which that member is responsible. The procedure in regard to such question is the same as that followed in the case of questions addressed to a minister. The list of start, unstart, short notice questions and questions to private members are printed in green, white, light pink and yellow color respectively to distinguish them from one another. 0 hour. Unlike the question hour, the 0 hour is not mentioned in the rules of procedure. Thus, it is an informal device available to the members of the parliament to raise matters without any prior notice. The 0 hour starts immediately after the question hour and lasts until the agenda for the day, that is, regular business of the House, is taken up. In other words, the time gap between the question hour and the agenda is known as 0 hour. It is an Indian innovation in the field of parliamentary procedures and has been in existence since 1962. Motions. No discussion on a matter of general public importance can take place except on a motion made with the consent of the presiding officer. The House expresses its decisions or opinions on various issues through the adoption or rejection of motions moved by either ministers or private members. The motions moved by the members to raise discussions on various matters fall into three principal categories. Number 1. Substantive motion. It is a self-contained, independent proposal dealing with a very important matter like impeachment of the President or removal of Chief Election Commissioner. Number 2. Substitute motion. It is a motion that is moved in substitution of an original motion and proposes an alternative to it. If adopted by the House, it supersedes the original motion. Number 3. Subsidiary motion. It is a motion that by itself has no meaning and cannot state the decision of the House without reference to the original motion or proceedings of the House. It is divided into three subcategories. Number 1. Anceliary motion. It is used as the regular way of proceeding with various kinds of business. Number 2. Superseding motion. It is moved in the course of debate on another issues and seeks to supersede that issue. Number 3. Amendment. It seeks to modify or substitute only a part of the original motion. Closer motion. It is a motion moved by a member to cut short the debate on a matter before the House. If the motion is approved by the House, debate is stopped forthwith and the matter is put to vote. There are four kinds of closer motions. Simple closure. It is one when a member moves that the matter having been sufficiently discussed be now put to vote. Closure by compartments. In this case, the clauses of a bill or a lengthy resolution are grouped into parts before the commencement of the debate. The debate covers the part as a whole and the entire part is put to vote. Kangaroo closure. Under this type, only important clauses are taken up for debate and voting and the intervening clauses are skipped over and taken as passed. Guillotine closure. It is one when the undiscussed clauses of a bill or a resolution are also put in vote along with the discussed one due to want of time, as the time allotted for the discussion is over. Privilege motion. It is concerned with the breach of parliamentary privileges by a minister. It is moved by a member when he feels that a minister has committed a breach of privilege of the House or one or more of its members by withdrawing fact of a case or by giving wrong or distorted fact. Its purpose is to censor the concerned minister. Calling attention motion. It is introduced in the parliament by a member to call the attention of a minister to a matter of urgent public importance and to seek an authoritative statement from him on that matter. Like the zero hour, it is also an Indian innovation in the parliamentary procedure and has been in existence since 1954. However, unlike the zero hour, it is mentioned in the rules of procedure. Adjournment motion. It is introduced in the Parliament to draw attention of the House to a definite matter of urgent public importance and needs the support of 50 members to be admitted. As it interrupts the normal business of the House, it is regarded as an extraordinary device. It involves an element of censure against the government, and hence Rajya Sabha is not permitted to make use of this device. The discussion on an adjournment motion should last for not less than 2 hours and 30 minutes. The right to move a motion for an adjournment of the business of the House is subject to the following restrictions. Number 1, it should raise a matter which is definite, factual, urgent, and of public importance. Number 2, it should not cover more than one matter. Number 3, it should be restricted to a specific matter of recent occurrence and should not be framed in general terms. Number 4, it should not raise a question of privilege. Number 5, it should not revive discussion on a matter that has been discussed in the same session. Number 6, it should not deal with any matter that is under adjudication by court. Number 7, it should not raise any question that can be raised on a distinct motion. No confidence motion. Article 75 of the Constitution says that the Council of Ministers shall be collectively responsible to the Lok Sabha. It means that the ministry stays in office so long as it enjoys confidence of the majority of the members of the Lok Sabha. In other words, the Lok Sabha can remove the ministry from office by passing a no confidence motion. The motion needs the support of 50 members to be admitted. Confidence motion. The motion of confidence has come up as a new procedural device to cope with the emerging situations of fractured mandates resulting in hung parliament, minority governments, and coalition governments. The governments formed with wafer-thin majority have been called upon by the President to prove their majority on the floor of the House. The government of the day, sometimes on its own, seeks to prove its majority by moving a motion of confidence and winning the confidence of the House. If the confidence motion is negative, it results in the fall of the government. Censure motion. A censure motion is different from a no confidence motion. Motion of thanks. The first session after each general election and the first session of every fiscal year is addressed by the President. In this address, the President outlines the policies and programs of the government in the preceding year and ensuing year. This address of the President, which corresponds to the speech from the throne in Britain, is discussed in both the Houses of Parliament on a motion called the motion of thanks. At the end of the discussion, the motion is put to vote. This motion must be passed in the House, otherwise it amounts to the defeat of the government. This inaugural speech of the President is an occasion available to the members of Parliament to raise discussion and debates, to examine and criticize the government and administration for its lapses and failures. No day yet named motion. It is a motion that has been admitted by the Speaker, but no date has been fixed for its discussion. The Speaker, after considering the state of business in the House and in consultation with the state of business in the consultation with the leader of the House or on the recommendation of the Business Advisory Committee, allots a day or days or part of a day for the discussion of such a motion. Dilatory motion. It is a motion for the adjournment of the debate on a bill, motion, resolution, etc., or a motion to retard or delay the progress of business under consideration of the House. It can be moved by a member at any time after a motion has been made. The debate on a dilatory motion must be restricted to the matter contained in such motion. If the Speaker is of the opinion that such a motion is an abuse of the rules of the House, he may either forthwith put the question thereon or decline to propose the question. Point of order. A member can raise a point of order when the proceedings of the House do not follow the normal rules of procedure. A point of order should relate to the interpretation or enforcement of the rules of the House or such articles of the Constitution that regulate the business of the House and should raise a question that is within a cognizance of the Speaker. It is usually raised by an opposition member in order to control the government. It is an extraordinary device as it suspends the proceedings before the House. No debate is allowed on a point of order. Censure motion versus no confidence motion. Number 1. Censure motion should state the reason for its adoption in the Lok Sabha, while no confidence motion need not state the reasons for its adoption in the Lok Sabha. Number 2. Censure motion can be moved against an individual minister or a group of ministers or the entire council of ministers, while no confidence motion moved against the entire council of ministers only. Number 3. Censure motion is moved for censoring the council of ministers for specific policies and actions, while no confidence motion is moved for ascertaining the confidence of Lok Sabha in the council of ministers. Number 4. Censure motion is passed in the Lok Sabha. The council of ministers need not resign from the office, while no confidence motion, if it is passed in the Lok Sabha, the council of ministers must resign from the office. Half an hour discussion. It is meant for discussing a matter of sufficient public importance which has been subjected to a lot of debate and the answer to which needs elucidation on a matter of fact. The Speaker can allot 3 days in a week for such discussion. There is no formal motion or voting before the House. Short duration discussion. It is also known as 2-hour discussion, as the time allotted for such a discussion should not exceed 2 hours. The members of the Parliament can raise such discussions on a matter of urgent public importance. The Speaker can allot 2 days in a week for such discussions. There is neither a formal motion before the House nor voting. This device has been in existence since 1953. Special motion mention. A matter which is not a point of order or which cannot be raised during question hour, half an hour discussion, short duration discussion, or under adjournment motion, calling attention notice, or under any rule of the House can be raised under the special mention in the Rajya Sabha. Its equivalent procedural device in the Lok Sabha is known as notice mentioned under Rules 377. Resolutions. The members can move resolutions to draw the attention of the House or the government to matters of general public interest. The discussion on a resolution is strictly relevant to and within the scope of the resolution. A member who has moved a resolution or amendment to a resolution cannot withdraw the same except by leave of the House. Resolutions are classified into 3 categories. Number 1. Private member's resolution. It is one that is moved by a private member other than a minister. It is discussed only on alternate Fridays and in the afternoon sittings. Number 2. Government resolution. It is one that is moved by a minister. It can be taken up any day from Monday to Thursday. Number 3. Statutory resolution. It can be moved either by a private member or a minister. It is so called because it is always tabled in pursuance of a provision in the Constitution or an Act of Parliament. Resolutions are different from motions in the following respect. All resolutions come in the category of substantive motions. That is to say, every resolution is a particular type of motion. All motions need not necessarily be substantive. Further, all motions are not necessarily put to vote of the House, whereas all the resolutions are required to be voted upon. Youth Parliament. The schemes of Youth Parliament was started on the recommendation of the 4th All India Whips Conference. Its objectives are: number 1, to acquaint the younger generations with practices and procedures of Parliament; number 2, to imbibe the spirit of discipline and tolerance cultivating character in the minds of youth; number 3, to inculcate in the student community the basic values of democracy and to enable them to acquire a proper perspective on the functioning of democratic institutions. The Ministry of Parliamentary Affairs provides necessary training and encouragement to the states in introducing the scheme. Legislative procedure in Parliament. The legislative procedure is identical in both the houses of Parliament. Every bill has to pass through the same stages in each house. A bill is a proposal for legislation and it becomes an act or law when duly enacted. Bills introduced in the Parliament are of two kinds: public bills and private bills, also known as government bills and private members' bill, respectively. Though both are governed by the same general procedure and pass through the same stages in the House, they differ in various respects. The bill introduced in the Parliament can also be classified into four categories. Number 1, ordinary bill, which are concerned with any matter other than financial subjects. Number 2, money bill, which are concerned with the financial matters like taxation, public expenditure, etc. Number 3, financial bills, which are also concerned with financial matters but are different from money bills. Number 4, Constitution Amendment bills, which are concerned with the amendment of the provisions of the Constitution. The Constitution has laid down separate procedures for the enactment of all the four types of bills. The procedures with regard to ordinary bills, money bills, and financial bills are explained here. The procedure with regard to the Constitution Amendment Bill is explained further. Ordinary bills. Every ordinary bill has to pass through the following 5 stages in the Parliament before it finds a place on the statute book. Number 1, first reading. An ordinary bill can be introduced in either House of Parliament. Such a bill can be introduced either by a minister or by any other member. The member who wants to introduce the bill has to ask for the leave of the House. When the House grants leave to introduce the bill, the mover of the bill introduces it by reading its title and objectives. No discussion on the bill takes place at this stage. Later, the bill is published in the Gazette of India. If a bill is published in the Gazette before its introduction, leave of the House to introduce the bill is not necessary. The introduction of the bill and its publication in the Gazette constitute the first reading of the bill. Public will versus private will. Number 1. Public bill is introduced in the Parliament by a minister, while a private member bill is introduced by any member of Parliament other than a minister. Number 2. Public bill reflects of the policies of the government ruling party, while private bill reflects the stand of opposition party on public matter. Number 3. Public bill has greater chance to be approved by the Parliament, while private bill has lesser chance to be approved by the Parliament. Number 4. Public bill rejection by the House amounts to the expression of wants of parliamentary confidence in the government and may lead to its resignation, while rejection of private bill by the House has no implication on the parliamentary confidence in the government or its resignation. Number 5. Public bill's introduction in the House requires 7 days notice, while introduction in the House of private member bill requires 1 month's notice. Number 6. Public bill is drafted by the concerned department in the consultation with the law department, while private member bill is drafted by the responsibility of the member concerned. Number 2. Second reading of ordinary bill. During this stage, the bill receives not only the general but also the detailed scrutiny and assumes its final shape. Hence, it forms the most important stage in the enactment of a bill. In fact, this stage involves 3 more sub-stages, namely stage of general discussion, committee stage, and consideration stage. Stage of general discussion. The printed copies of the bill are distributed to all the members. The principles of the bill and its provisions are discussed generally, but the details of the bill are not discussed. At this stage, the House can take any one of the following four actions. Number 1. It may take the bill into consideration immediately or on some other fixed date. Number 2. It may refer the bill to a select committee of the House. Number 3. It may refer the bill to a joint committee of the two houses. Number 4. It may circulate the bill to elicit public opinion. A select committee consists of members of the House where the bill has originated, and a joint committee consists of members of both the Houses of Parliament. Committee stage. The usual practice is to refer the bill to a select committee of the House. This committee examines the bill thoroughly and in detail, clause by clause. It can also amend its provisions but without altering the principle underlying it. After completing the scrutiny and discussion, the committee reports the bill back to the House. Consideration stage. The House, after receiving the bill from the Select Committee, considers the provisions of the bill clause by clause. Each clause is discussed and voted upon separately. The members can also move amendments and, if accepted, they become part of the bill. Number 3. Third reading. At this stage, the debate is confined to the acceptance or rejection of the bill as a whole, and no amendments are allowed, as the general principles underlying the bill have already been scrutinized during the stage of second reading. If the majority of members present and voting accept the bill is regarded as passed by the House. Therefore, the bill is authenticated by the presiding officer of the House and transmitted to the second House for consideration and approval. A bill is deemed to have been passed by the Parliament only when both the Houses have agreed to it, either with or without amendments. Number 4. Bill in the second House. In the second House also, the bill passes through all the three stages, that is first reading, second reading and third reading. There are four alternatives before this House. Number 1. It may pass the bill as sent by the first House, that is without amendments. Number 2. It may pass the bill with amendments and return it to the first House for reconsideration. Number 3. It may reject the bill altogether. Number 4. It may not take any action and thus keep the bill pending. If the second House passes the bill without any amendments or the first House accepts the amendments suggested by the second House, the bill is deemed to have been passed by both the Houses and the same is sent to the President for his assent. On the other hand, if the first House rejects the amendments suggested by the second House, or the second House rejects the bill altogether, or the second House does not take any action for 6 months, a deadlock is deemed to have taken place. To resolve such a deadlock, the President can summon a joint sitting of the two Houses. If the majority of the members present and voting in the joint sitting approves the bill is deemed to have been passed by both the Houses. Number 5. Assent of the President. Every bill, after being passed by both the Houses of Parliament, either singly or at a joint sitting, is presented to the President for his assent. There are three alternatives before the President. Number 1, he may give his assent to the bill. Number 2, he may withhold his assent to the bill. Number 3, he may return the bill for reconsideration of the House. If the President gives his assent to the bill becomes an act and is placed on the statute book. If the President withholds his assent to the bill, it ends and does not become an act. If the President returns the bill for reconsideration and if it is passed by both the Houses, again with or without amendments, and presented to the President for his assent, the President must give his assent to the bill. Thus, the President enjoys only a suspensive veto. Money bills. Article 110 of the Constitution deals with the definition of money bills. It states that a bill is deemed to be a money bill if it contains only provisions dealing with all or any of the following matters. Number 1. The imposition, abolition, remission, alteration or regulation of any tax. Number 2. The regulation of the borrowing of money by the Union Government. Number 3. The custody of the Consolidated Fund of India or the Contingency Fund of India, the payment of monies into or withdrawal of money from any such fund. Number 4. The appropriation of money out of the Consolidated Fund of India. Number 5. Declaration of any expenditure charged on the Consolidated Fund of India or increasing the amount of any such expenditure. Number 6. the receipt of money on account of the Consolidated Fund of India or the public account of India, or the custody or issue of such money, or the audit of the accounts of the union or of a state. Number 7. Any matter incidental to any of the matters specified above. However, a bill is not to be deemed to be a money bill by reasons only that it provides for: number 1, the imposition of fines or any other pecuniary penalties; number 2, the demand or payment of fees for licenses or fees for service rendered; number 3, the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purpose. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the Lok Sabha is final. His decision in this regard cannot be questioned in any court of law or in the either House of Parliament or even the President. When a money bill is transmitted to the Rajya Sabha for recommendation and present through the President for assent, the Speaker endorses it as a money bill. The Constitution lays down a special procedure for the passing of money bills in the Parliament. A money bill can only be introduced in the Lok Sabha, and that too on the recommendation of the President. Every such bill is considered to be a government bill and can be introduced only by a minister. After a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its consideration. The Rajya Sabha has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make the recommendations. It must return the bill to the Lok Sabha within 14 days, whether with or without recommendations. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. If the Lok Sabha accept any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. If the Lok Sabha does not accept any recommendation, the bill is then deemed to have passed by both the houses in the form originally passed by the Lok Sabha without any change. If the Rajya Sabha does not return the bill to the Lok Sabha within 14 days, the bill is deemed to have been passed by both the houses in the form originally passed by the Lok Sabha. Thus, the Lok Sabha has more powers than Rajya Sabha with regard to a money bill. On the other hand, both the houses have equal powers with regard to an ordinary bill. Finally, when a money bill is presented to the President, he may either give his assent to the bill or withhold his assent to the bill, but cannot return the bill for reconsideration of the houses. Normally, the President gives his assent to a money bill as it is introduced in the Parliament with his prior permission. Financial bills. Financial bills are those bills that deal with fiscal matters, that is, revenue or expenditure. However, the Constitution uses the term financial bill in a technical sense. Financial bills are of three kinds: Money Bill, Article 110, Financial Bill 1, Article 117, Clause 1, Financial Bills 2, Article 117, Clause 3. This classification implies that money bills are simply a species of financial bills. Hence, all money bills are financial bills, but all financial bills are not money bills. Only those financial bills are money bills which contain exclusively those matters which are mentioned in Article 110 of the Constitution. These are also certified by the Speaker of the Lok Sabha as money bills. The financial bills, first and second, on the other hand, have been dealt with in Article 117 of the Constitution. Ordinary bill versus money bill. Number 1. Ordinary bill can be introduced either in the Lok Sabha or the Rajya Sabha, while money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha. Number 2. Ordinary bill can be introduced either by a minister or by a private member, while money bill can be introduced only by a minister. Number 3. Ordinary bill is introduced without the recommendation of the President, while money bill can be introduced only on the recommendation of the President. Number 4. Ordinary bill can be amended or rejected by the Rajya Sabha, while money bill cannot be amended or rejected by the Rajya Sabha. The Rajya Sabha should return the bill with or without recommendations which may be accepted or rejected by the Lok Sabha. Number 5. Ordinary bills can be detained by the Rajya Sabha for a maximum period of 6 months, while money bill can be detained by the Rajya Sabha for a maximum period of 14 days only. Number 6. Ordinary bill does not require the certification of the speaker, while money bill requires the certification of the speaker when transmitted to the Rajya Sabha. Number 7. Ordinary bill is sent for the President assent only after being approved by both the houses. In case of a deadlock due to disagreement between the two houses, a joint sitting of both the houses can be summoned by the President to resolve the deadlock, while money bill is sent for the President assent even if it is approved by only Lok Sabha. There is no chance of any disagreement between the two houses, and hence there is no provision of joint sitting of both the houses in this regard. Number 8. Ordinary bill defeat in the Lok Sabha may lead to the resignation of the government if it is introduced by a minister, while money bill's defeat in the Lok Sabha leads to the resignation of the government. Number 9. Ordinary bill can be rejected, approved or returned for reconsideration by the President, while money bill can be rejected or approved but cannot be returned for reconsideration by the President. Financial bills first. A financial bill first is a bill that contains not only any or all the matters mentioned in Article 110 but also other matters of general legislation. For instance, a bill that contains a borrowing clause but does not exclusively deal with borrowing. In two respects, a financial bill 1 is similar to a money bill. Both of them can be introduced only in the Lok Sabha and not in Rajya Sabha. Both of them can be introduced only in the recommendation of the President. In all other respects, a financial bill first is governed by the same legislative procedure applicable to an ordinary bill. Hence, it can be either rejected or amended by the Rajya Sabha, except that an amendment other than for reduction or abolition of a tax cannot be moved in either house without the recommendation of the President. That is, the recommendation of the President is not required for moving an amendment making provision for the reduction or abolition of a tax. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration of the House. Financial Bill 2. A Financial Bill 2 contains provisions involving expenditure from the Consolidated Fund of India but does not include any of the matters mentioned in Article 110. It is treated as an ordinary bill and in all respect it is governed by the same legislative procedure which is applicable to an ordinary bill. The only special feature of this bill is that it cannot be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Hence, Financial Bill 2 can be introduced in either House of Parliament and recommendation of the President is not necessary for its introduction. In other words, the recommendation of the President is not required at the introduction stage but is required at the consideration stage. It can be either rejected or amended by either House of Parliament. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of two houses to resolve the deadlock. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration of the houses. Joint sitting of two houses. Joint sitting is an extraordinary machinery provided by the Constitution to resolve a deadlock between the two houses over the passage of a bill. A deadlock is deemed to have taken place under any one of the following three situations after a bill has been passed by one house and transmitted to the other house. Number 1. If the bill is rejected by the other house. Number 2. If the houses have finally disagreed as to the amendments to be made in the bill. Number 3. If more than 6 months have elapsed from the date of the receipt of the bill by the other house without the bill being passed by it. In the above three situations, the President can summon both the houses to meet it in a joint sitting for the purpose of deliberating and voting on the bill. It must be noted here that the provision of joint sitting is applicable to ordinary bills or financial bills only and not to money bills or constitutional amendment bills. In the case of a money bill, the Lok Sabha has overriding powers, while a constitutional amendment bill must be passed by each house separately. In reckoning the period of 6 months no account can be taken of any period during which the other house to which the bill has been sent is prorogued or adjourned for more than 4 consecutive days. If the bill under dispute has already lapsed due to the dissolution of Lok Sabha, no joint sitting can be summoned, but the joint sitting can be held if the Lok Sabha is dissolved after the President has notified his intention to summon such a sitting, as the bill does not lapse in this case. After the President notifies his intention to summon a joint sitting of the two houses, none of the houses can proceed further with the bill. The Speaker of Lok Sabha presides over a joint sitting of the two houses and the Deputy Speaker in his absence. If the Deputy Speaker is also absent from a joint sitting, the Deputy Chairman of Rajya Sabha presides. If he is also absent, such other person as may be determined by the members present at the joint sitting presides over the meeting. It is clear that the Chairman of Rajya Sabha does not preside over a joint sitting, as he is not a member of either House of Parliament. The quorum is to constitute a joint sitting is 1/10 of the total number of members of the two houses. The joint sitting is governed by the rules of procedure of Lok Sabha and not of Rajya Sabha. If the bill in dispute is passed by a majority of the total number of members by both the houses present and voting in the joint sitting, the bill is deemed to have been passed by both the houses. Normally, the Lok Sabha with greater number wins a battle in a joint sitting. The Constitution has specified that at a joint sitting, new amendments to the bill cannot be proposed except in two cases. Number one, those amendments that have caused final disagreement between the two houses. Number two, those amendments that might have become necessary due to the delay in the passage of the bill. Since 1950, the provision regarding the joint sitting of the two houses has been invoked only thrice. The bills that have been passed at joint sittings are: number 1, Dowry Prohibition Bill 1960, number 2, Banking Service Commission Repeal Bill 1977, number 3, Prevention of Terrorism Bill 2022.